둘째 날 마지막 세션입니다. 마지막 세션이지만 가장 하이라이트라고 할 수 있는 정책 토론회가 되겠습니다. 지금까지 주로 이 총론적인 얘기들이 많이 있었는데 이제 강론적인 얘기를 좀 더 구체적으로 또 우리 외국과 한국의 상황을 좀 비교해가면서 한국적 함의를 얻을 수 있는 그런 귀한 시간이 될 것 같습니다. 오늘 저희가 좀 이 발제해 주실 분들, 토론해 주실 분들이 굉장히 많습니다. 그래서 가능하면 시간을 지켜가면서 저희가 이 진행을 하도록 하겠습니다. 정책 토론회 한국 기부 법 정책 개선을 위한 도전 과제라는 주제입니다. 발제 1은 영국의 체리티 커미션에서 오신 이 Kenneth Dibble 이 선생님이십니다. 예, 박수로 환영해 주시기 바랍니다.
It's English humour, I know, but sessions in the UK which take place immediately after lunch are known as the graveyard sessions. And you might wonder why that is, but I think what it means is that both the speaker and the audience must be alert, especially alert after lunch. The scope of today was twofold. It was to promote a charitable giving culture in Korea and the empowerment of civil society in Korea. And you might well ask the question, well, what does the regulatory framework have to do with both of those questions that have been raised? And the answer is not everything, but it is something. For example, you can have a regulatory system which is imperfect, but works very well, because those who organise it and administer it know what they're about, and they do it in such a way to promote charitable giving and building capacity in civil society. On the other hand, you can have a very sophisticated regulatory system with all sorts of powers and authorities which regulates very badly. So it's not necessarily what you have to regulate which gives the product. It's the way the regulation actually is pursued by those who are responsible for the regulation. But to get off in a good footing, of course, a good legal framework is better than not having a good legal framework, and one stands a better chance of discharging those two questions, promoting charitable giving in Korea and building civil society, if one has as an underlying base a good regulatory system. And that's what we think we have in the United Kingdom, particularly in England and Wales, and in other parts which are modelled on the England and Wales model. So this afternoon, within the 30 minutes allotted, I will try and endeavour to drill down in much more detail than I did yesterday about how the Commission actually functions and the powers which it functions, which emanate now from the Charities Act of 2011, which is a consolidated act bringing together the Charities Act of 2006 and the Charities Act of 1993. So, for an overview, the present law of charity and the development of charity in the United Kingdom dates from 1601. So there's well under over 400 years of charity in the United Kingdom, so it's a well-established institution. And the Commission itself was established by statute in 1853. So the Commission's been around for 150 years, even though the sector is much older. And you might ask, well, how was the sector regulated before 1853? And the answer was that charities who misbehaved themselves in any way were brought before the courts by the Attorney General, which remains today constitutionally as the body within government which protects charitable interests. But all charity regulation is devolved onto the Charity Commission. There's been a number of Charities Acts. I've listed these on the slide. 1960, 1985, 1992, 1993, 2006 and 2011. The 2011 Act, as I say, represents the comprehensive statement of the Commission and its powers to regulate. But the modern form of the Commission actually dates from 1960 Act, where the Commission was charged with maintaining a public register of charities, and that was a seminal statute, really, which brought about the Commission in its modern form. We run on a budget of about 22 million pounds sterling. We have 290 staff based in the offices of Liverpool, London, Taunton and Newport. As I say, the regulatory framework is governed by the 2011 Act, and charities themselves are not necessarily governed by that legislation. They're governed at what we call common law, the common law of England and Wales, added to by statute. And the role of the regulator, well, as I've just said, it's got a deep historical provenance within the United Kingdom. It's well established as part of the social norms and social economy in the United Kingdom, and it makes a significant contribution to volunteering and social and economic life of the country. I'll say later on, but 1 in 20 people in the UK are involved in volunteering for charity. And the regulation, the way it's been structured, is of a purposive kind. It's there to promote public confidence in charity, to enable the charitable sector to maintain itself and develop for the benefit of civil society and communities, which actually answers the two questions which are the scope of today's work. And we operate on what is known as the principles of best regulatory practice. These are common throughout regulators operating in the United Kingdom. We have to operate in a proportionate way. We have to be accountable. We have to be consistent. We have to be transparent and targeted only at cases where action is needed. Now that is written in to the Commission statute 2011. It's actually written into the statute. So we are required to behave in that way. We have a duty, one of our principal duties is to support charitable giving and volunteering, and of course our general aim is to support the development of the charitable sector. So it's regulation which has a purpose behind it, a purpose which actually answers the two questions which are the scope of today's work. As I say, generally directed at promoting trust and confidence in charity, create a healthy sector in terms of social and economic contribution to society and the development and support of civil society and communities, should maximise social engagement through volunteering and financial giving, and that is underpinned by substantial principal fiscal reliefs available to charities. And above all, and the point I made yesterday, this regulation is not for the benefit of charities directly. It's regulation in the public interest, although charities, of course, benefit from that, but it's regulation in the public interest, not in the interest of the sector in itself. And you saw this slide yesterday, which sets out the regulated sector in England and Wales. I'll go through it very quickly. 165,000 odd charities which are registered. There's probably another 80,000 which are unregistered. They're not required to register. Annual income, 68 billion, equivalent to the agricultural sector in England and Wales. So it's a substantial sector. Assets about 232 billion. And the sector is highly skewed in terms of a small number of very large charities and a large number of very small charities, which you can see from the slide. The sector is responsible for nearly getting on for 1 million paid staff and another 1 million trustees who act without remuneration, which are responsible for running these organisations, and about 1 in 20 of population are active volunteers for charity. So Charity is well embedded in English society and will remain so, and our responsibility is to maintain the activity of charity in their social contribution. The Commission, again, modern form, as I say, dates from 1960. It's an independent, unitary civil regulator. It's only a civil regulator. It has no powers to prosecute criminal behaviour. It's a civil regulator, and it's the model for the other UK charity regulators, OSCR, and which is the Office of the Scottish Charity Commission and the Charity Commission for Northern Ireland, and the model is likely to be followed, has been followed in Ireland. The principles of the Charity Commission, the regulatory principles, are seen as the gold standard for charity and MPO regulation. But it's interesting, although, and I'll come to in a minute, the actual the objectives and the functions and duties of the Commission, a really ambitious regulatory remit set by Parliament in the 2006-2011 Act, but unfortunately funding still remains an issue. You might have picked up that trying to effectively regulate 165,000 charities plus on a budget of 21 million, given the asset value of the sector and the income of the sector, is not a good ratio in terms of assets deployed and the outcome hoped to be achieved. So a very ambitious regulatory remit which was set for the Commission, but it's not been necessarily matched by funding. And now these are the Commission's statutory objectives. They are set out in its governing statute: to increase public trust and confidence in charities, to promote awareness and understanding of the public benefit requirement, to promote compliance by charity trustees with their legal obligations, to promote the effective use of charitable resources, and to enhance the accountability of charities to donors, beneficiaries and the general public. So anything we do, anything the Commission does, has to have its genesis in those statutory objectives which have been set by Parliament, which are set out in the Charities Act 2011. And these are its main functions, which are again set out in the statute. We have a power to determine whether organisations are charities, and that's a specific issue which I'll come to later on. We have to maintain an accurate and up-to-date public register of charities, and those who heard me yesterday heard me talk about how essential it is for public accountability that there is a public record of what charities exist, and of course those organisations which benefit from fiscal reliefs. We are charged with encouraging and facilitating the better administration of charities, including giving advice and guidance. And very importantly, the fourth bullet, we're charged with identifying and investigating charity abuse and to take remedial and protective steps to deal with abuse and safeguard charity property. And finally, we're charged with obtaining, evaluating and disseminating information about charities, including maintaining an accurate and up-to-date register. So this is what we do. The objectives are first, and this is what we do. And these are our main duties, which are again enshrined in the statute. We must act compatibly with our objectives. So everything we do must flow from the objectives. We must act, and absolutely critical, this second point, we must act compatibly with the encouragement of volunteering and charitable giving. That means the poise of regulation mustn't stifle charities. It must be sufficient to allow wrongdoing to be seen and dealt with by the Commission, but it mustn't be so harsh as to actually crush the sector and prevent it from operating. So that's a particular aspect which we have to have regard to. We have to act proportionately. We have to, facilitate innovation by charities. We have to encourage innovation by charities. And of course, we have to be efficient and effective use of resources, as you expect from any public body, and we have to exercise good corporate governance. Again, you'd expect that from any public body. So the scope of our regulation, this is set out again in the statute. We have to maintain a public register of charities. We provide general advice and guidance. This is largely web-based. We confer regulatory consents, and this is assist charities in their operations. And fourth bullet, identifying abuse and acting to protect charity property and evaluating information about charities and disseminating them in an accessible form, and that includes getting accounts and returns and submissions from charities which they're required to provide us on an annual basis. One of the distinct aspects of charity regulation in the UK is that the definition of charity is a technical legal one and quite difficult, I think, sometimes to understand, except at a very high level of abstraction. But the benefit of this is that MPOs and charities who are registrable have to confine and confirm themselves to a particular legal standard. And this means that certain organizations, for example, political organizations, are excluded. Now, in other jurisdictions, you do not find such a strict definition of what is an MPO. And that means that the sector itself is more loosely constructed. And this in itself sometimes brings tensions with government, because the government may regard certain MPOs which come under the more general description of an MPO as, shall we say, not sympathetic all the time to their cause. And this causes tensions between government and the MPO sector. But in the UK, because of the tight definition of charity, which excludes charities with political and propagandist purposes, we don't get that same sort of tension, although charities are, of course, free to criticise government policy, which they do repeatedly, much to the annoyance of government, and they're free to put forward their views, but they cannot be political organisations and they cannot be propagandist organisations. So to be a charity, this is defined both in the common law, case law going back 300 years, and under the Charities Act of 2006, now the 2011 Act. It can be quite complicated, but it, of course, keeps people like me in a job, having to identify and interpret the law. To be a charity, an organisation must be subject to the court's charity law jurisdiction, so it must be, as we say, established within the laws of England and Wales. And there's issues there of, is it domiciled within England and Wales? Technical term, I imagine you have the same in Korean law. And is it independent? Then does it have a purpose falling within the descriptions of purposes? These were set out in the new legislation. And it has to be established for the public benefit, and it must be exclusively charitable. You cannot have a body which is part charitable and part non-charitable. It has to be exclusively charitable. So the registration of charities, there is a legal obligation on both trustees and the Commission to register a charity. The registration of charity is not a licensing system to operate. What it is a recognition of a legal status. So apart from a new organisation, the CIO, the Charitable Incorporated Organisation, which is slightly different, a body exists as a charity before it registers with the Commission. And the registration is just a recognition of that legal status. But trustees are obliged, if it's registrable with an income of over £5,000, it's bound to register, and it can be made to register if it's not. So the public has some sort of assurance that if there is a charity in existence within England and Wales with an income of over £5,000, if it's not on the register, there's something wrong, and they shouldn't be giving to it or communicating or dealing with it. Now, this again is perhaps quite a difficult concept. It's based very much around English law. What legal form can be a charity? The problem for us, of course, I've set out on the slide there 7 ways in which a legal form can exist for a charity, and each of these ways has the legal form have slightly different law in relation to their governance. So again, you know, this complexity keeps people like me in employment, having to deal with the various issues and problems which arise in charities. I mean, the first is very quaintly a trust. The English law of trust, for those you know their law and jurisprudence. The English law of trust is a very old established form dating back to the Middle Ages, and still common and still used. And they can be created by a trust deed or will. An unincorporated association based on constitution, that's not on rules, that's all rules. A company structure, company limited by guarantee, normally guarantee, but I think unlike the American jurisdiction, you can establish a charitable company limited by shares. They're very rare, but they're not profit distributing shares, I might add immediately. Charity created or constituted by Act of Parliament. You may have heard of the RSPCA, the Royal Society of Protection of Cruelty to Animals. That's created by an Act of Parliament. Charity created by, under the Royal Prerogative, a Royal Charter. Well, the Royal Albert Hall Recreation Centre in London, that's constituted under Royal Charter. Charity governed by commission scheme, well, the Wellcome Trust, which was originally one of the biggest medical research charities in the UK, with an asset value of nearly 19 billion, was created by the will of Sir Henry Wellcome, a great philanthropist in the 1930s. But now we made what we call a scheme is a legal document, and that document now governs that charity. And finally, the new legal form brought in by the 2006 Act was a charitable incorporated organization. And this has the benefits of incorporation, but is not a company. I can't go through this in the 30-minute stricture, but it's an entirely new corporate body created by statute with its own jurisprudence, which governs its creation, its life, and its dissolution. It's not a company. Company in English law, they're commercial entities, really. And they can be charities, but their constitutions have to be modified in a particular way. This new vehicle, the charitable incorporated organization, is a means of having a corporate body for a charity which is not a company. Therefore, there's no dual regulation by a Companies House because it's not a charity. 10 minutes, thank you very much. Need to fire on. Now, these are the descriptions of purposes listed in the legislation. There are 12 of them, plus a residual category at the end, which I'll talk about. Interestingly enough, if you look at the various constitutions around the world, various laws governing charities, which actually set out charitable purposes in the statute, you find many of these. These are not so dissimilar, I think, from what you might have in Korea as recognizing purposes which should be awarded special social status because they are charities. But they're not without difficulty. For example, I'll just point out the advancement of religion. It causes us great difficulty at the moment. When you come outside the main religions, Islam, Hinduism, Buddhism, Christianity, Jewish religion, and you come into new religious movements, this is a very technical and difficult area. 15 years ago, the Commission rejected Scientology as a religion. You've probably seen the decision on our website. And various other new religious movements come forward, and they're very difficult because the law in England and Wales has been developed around the notion of Christianity and Jewish religion, and it's very difficult to interpret that in the context of any new religions. Advancement of amateur sport, that is quite new in its sense. It's been further defined in the legislation as a sport or game which involves physical or mental exertion. So it's tied to the promotion of health, very much tied to the promotion of health. We've accepted games which stimulate the mind, like chess and bridge, actually, into this, and of course any sport where there's exertion. We recently had a case of target shooting, gun clubs, where they were trying to argue that the physical and mental exertion caused by shooting rifles at targets graduated to make it into the category of the advancement of amateur sport. Now, if you look at that definition, you might think it does, but if you look at the sub-definition, which is about promoting health by physical and mental exertion, after a lot of work on this, our view was it didn't pass the test. And we refused to register. The case has gone to the tribunal, the charity tribunal. It was argued about a month ago, and we're waiting to hear the result, because if we lose on this case, you can argue that playing billiards or darts or fishing may be charitable because of the physical or mental exertion which might flow on a minimalist scale. So it's quite an important test case, this. It's not because it's guns. I mean, guns are well regulated. The sport of target shooting is well regulated. The issue is it a charity? One of the difficulties we have advancement of human rights, that is a key issue for us, because the advancement of human rights may involve political activity and political purpose. And the problem there is which side of the line does it fall? Is it a political organization which is not acceptable, or is it advancing human rights for the public benefit, which is? Lots of problems around there. And the final residual category, this picks up what the professor was saying yesterday about the ability of any legal framework to anticipate what new purposes might come along in the future and have the framework able to adjust so it picks up new purposes which might be charitable for the public benefit. Public benefit, there's an absolute essential requirement. A purpose, even if it falls within those descriptions, will not be charitable unless it's for the public benefit. It must be clear what the benefits are. They're normally material, but they can be an intangible benefit, like promotion of animal welfare is an intangible benefit to benefiting the morality of humankind. A charity cannot have a political purpose. The beneficiaries, they must either be a section of the public, they might either be the public generally, or a sufficiently important section of the public which requires, which is disadvantaged in some way, which can benefit from the purpose. People in poverty cannot be excluded from benefit, and of course any private benefit flowing from the organisation can only be accepted if it's incidental. Just go through this quickly. I mentioned it. Charity cannot have a political purpose under English law because the public benefit cannot be ascertained and it usurps the function of Parliament, which is the lawmaker. And the definition is quite broad. It's not just party political, but any activity which seeks to oppose or change the law or policies of the government, either the UK government or government overseas. But if the body has a charitable purpose, it can carry out some political activities, provided they are supported by the charity's purposes and they don't become the dominant activity on a permanent basis. And of course, they cannot be party political in any way. The other special characteristic is trading. Charities cannot trade commercially unless they are trading in furtherance of their purposes, like a charity for the benefit of disabled can trade by making, producing wheelchairs. That's acceptable, but for any other activity, a charity's trading activities can only be seen as fundraising. They cannot be carried out by the charity itself. They're normally carried out through a subsidiary non-charitable body which covenants its profits under tax arrangements back to the charity, so the charity is not disadvantaged. The duties and responsibilities of trustees, I set this out on this slide. Going from left to right, trustees must act in the charity's best interest. They must manage their resources responsibly. They must comply with the governing document and the law. They must ensure charity is carrying out its purposes for the public benefit. They must act with reasonable care and skill, and they must assure the charity is accountable. These all emanate from the common law. They're not part of statute. Generally, they're part of the common law. The 6 main duties, and if you want to read about these in more detail, they're set out in a commission publication, which you'll find on our website, called The Essential Trustee. Our relationship with charities we see as a consensual one. You can't regulate a sector which is against what the Commission stands for. It's part of being a charity that you accept the regulation of charities by us. And the relationship is based on an obligation. You know, they run their own affairs. They must exercise their discretion with their objects and powers and legal requirements, but they must be open and honest with us, the regulator. They must follow our regulatory requirements, but they are, of course, if they think we're wrong, they're able to challenge that. They must be open, transparent, and accountable, and they must safeguard their reputation, property, and donors and beneficiaries. This is a really common law statement of principles of what charities should comply with. Just looking at the Commission's enabling functions, I've discussed many of these already. These are there to help and support charities in the main. We have a website, we have a contact centre, we have tailored advice, we have a whole raft of publications to help charities, what we call the rule book. I said yesterday, you cannot hold charities to account if they don't know what's expected of them. We call that the rule book. It's set out in all these documents. We make schemes and orders to authorise operation of charities, and we maintain a register of mergers for charities who wish to merger. Just some numbers, just to get the scale of things, over 7,000 applications to register in the last year, and 4,500 approved. We deregister about 3,000 charities a year, so it doesn't always go up because charities cease to operate, dissolve, come off the register. And there's a measure of our incoming traffic to first contact and the number of cases which we operate. But I imagine that the interesting feature is the number of new registrations each year. Our important compliance functions, we have a whole raft of powers to intervene in the charities' affairs. We investigate, we monitor charities through their accounts and general activity. We look at complaints that are made about charities, whether from the investigative press or from whistleblowers or from individuals who work in charities. We have extensive powers to protect charities. We can freeze bank accounts, restrain transaction of trustees, appoint managers, remove trustees and members. We can make remedial schemes. We can give directions to trustees to apply their charity property in the best way. And we can enter with a warrant to obtain and search premises if need be. So a whole raft of powers, and of course we also have power to go to the courts to recover charity property was lost. And some numbers here, 103 statutory inquiries opened last year. We currently run at about 250 statutory inquiries. They're the most serious cases. And if you look at 250 statutory inquiries against 165,000 registered charities, that's, you know, we're looking at a very small slice of what's going badly wrong in the sector. Our monitoring work, we do quite a lot of that, and the prevention, I mentioned just alerts. We published an alert, for example, on Syria. There were a lot of charities sending aid convoys to Syria, and there were issues of volunteers going in those convoys which wanted to end up fighting in ISIS. So we issued an alert to trustees to be aware. We do this from time to time. Just to look at our powers, investigative powers there. Substantial number used. Interim managers we appointed. They're temporary managers to run a charity where we sort the trustees out. And in terms of outcomes, that's the sort of figures that we put forward as our protection by our. Okay, thank you very much. I'll just wrap it up now. In the work we do. Accountability, this is very important. We're accountable for our actions to the tribunal and the courts for our legal decisions, to Parliament and parliamentary committees for our general conduct, to the UK Treasury and the National Audit Office for our use of public funds, and for liaison over policy and new legislation to the Cabinet Office and the Minister for Civil Society. But we're not accountable to them. We just liaise with them. And of course, overall, we're accountable to the general public for what we do. It won't go forward from that. I just think that's the end. The last slide, I think, was the last slide was just our strategic priorities. That quite quaint pictorial description I gave yesterday. And basically our strategic approach is one of giving public confidence to charities. We do that by protecting charities, by enabling charities, encouraging transparency, and of course being an efficient regulator. Thank you very much.
좋은 발제를 해주신 케네스 데블 씨에게 다시 한번 큰 박수로 감사 표시를 해주시기 바랍니다. 다음은 이제 그 미국의 사례입니다. 이 미국의 그 이 비영리 단체 거버넌스라든가 베스트 프랙티스에 대해서 어제 본인을 소개할 때 자랑스러운 대안의 딸이다 이렇게 소개를 하셨습니다. 미국 비영리 전문 변호사이신 심혜진 변호사께서 나오셔서 미국 사례를 발제해 주시겠습니다. 큰 박수로 맞아주시기 바랍니다.
안녕하세요. 심혜진 변호사입니다. 좋은 시간 되고 계시길 바랍니다. 이 지금 각도가 조금 제가 스크린도 보면서 또 여러분도 봤으면 좋겠는데 제가 어제 기존 강연을 통해서 미국의 비영리 법과 그 법 체계를 이제 전체적으로 소개를 했습니다. 비영리 기관의 종류와 법적 자격, 그리고 비영리 기관이 가지고 있는 그 국세청과 주정부 법무장관과의 그 특별한 관계들을 설명을 했는데 어제 강연 후에 좋은 질문들을 해주셨습니다. 그래서 감사합니다. 그 질문들을 토대로 몇 가지 보충 설명을 제가 하고 오늘 프레젠테이션을 시작하도록 하겠습니다. 우선 저희 강연은 법률 체계 또는 제도에 관한 내용이기 때문에 정부 규제에 대한 내용이 많이 있습니다. 하지만 유념하셔야 될 것은 미국의 비영리법 제도나 비영리법들은 그 어떤 통제의 개념보다는 혜택을 주었을 때 거기에 대한 규제 또는 책임을 지라고 하는 그런 내용들이라고 생각을 하시면 더 좋겠습니다. 미국의 비영리 그 제도 안에서는 비영리 기관들이 설립하고 운영하고 모금하는데 굉장히 자유롭습니다. 그래서 예를 들면 모금을 하는데 예산의 몇 프로 이상은 모금하는 자금을 사용하지 못한다. 이런 법들은 없습니다. 그래서 굉장히 자유롭고 마치 우리가 그냥 회사들이 운영을 하는 것처럼 목적이 비영리이고 그리고 그 안에서 개인적인 혜택을 받지 못하는 이익을 추구하지 못하는 이제 그런 아주 보편적인 법이 규제로 있을 뿐이지 그 외에는 굉장히 자유롭게 비영리들이 활동을 할 수가 있습니다. 그래서 예를 들면 뭐 기부금에 관해서도 기부금 자체를 어떤 것들은 기부를 할 수 있고 어떤 것들은 할 수 없으며 얼마까지 기부금을 낼 수 있고 없고에 대한 규정이 있는 게 아니라 그 기부금을 받았을 때 그거에 대한 책임을 가지고 목적대로 사용하고 그것을 사사로이 사용하지 말라라는 그런 규제라고 생각을 하시면 되겠습니다. 그리고 이런 규제가 있어야 되는 이유가 비영리 단체들이 투명성과 책임감을 가지고 활동할 수 있도록 돕기 위한 그런 근본적인 체제라고 생각하시면 되고 또 혜택을 줬으니까 내가 너희를 통제하겠다가 아니라 혜택을 줬으니까 거기에 책임을 지고 책임을 짐으로 말미암아 대중에게 더욱더 trust를 받고 그래서 그것 때문에 더욱더 비영리 단체가 활발하게 활동할 수 있는 그런 유형이라고 생각하시면 됩니다. 예를 들면 그러니까 이런 제도가 있기 때문에 미국 전체에서 지금 국세청에 등록된 비영리 단체만 해도 144만 개가 넘는데 등록이 안 된 비영리까지 합하면 훨씬 많을 것입니다. 근데 등록된 그 비영리 단체들은 그 모금 운동을 하는 단체들인데 그렇게 많은 단체들이 모금 운동을 할 수 있는 이유가 이런 제도가 뒷받침이 되어 있기 때문입니다. 예를 들면 뉴욕 같은 경우에는 어제 제가 말씀드렸듯이 뉴욕에만 해도 국세청에 등록된 비영리 단체가 거의 10만 개가 됩니다. 그런데 그 중에서 이제 제가 섬기는 제가 돕는 그런 비영리 단체들의 예를 조금 들면 뉴욕 시티 안에서 뉴욕 시티 같은 경우는 이제 서울이랑 좀 비슷하다고 생각하실 수 있는데 거기에는 미국 전체의 부가 아주 많이 축적이 되어 있습니다. 거기에서 활동하는 비영리 종교 단체 중에 하나는 예를 들면 매년 연말 12월이 되면 1년 예산의 30%의 기부를 받습니다. 근데 그 이유가 12월 달이 되면 많은 뉴욕에서 일하시는 분들이 보너스를 받아요. 근데 그 보너스를 받는 그 특별한 기간에 특별히 기부 운동을 할 수 있는 이유가 내가 내는 기부금이 내 전체 소득의 50%까지 개인 기부자가 공제를 받을 수 있기 때문입니다. 그런 근본적인 혜택이 있기 때문에 또 기부 문화가 더 발전을 할 수 있는 것입니다. 근데 그것은 어떤 회사에서 주는 기부금의 기준이 아니고 개인이 주었을 때 50%까지 내가 내 소득을 비영리 단체에다 주고 거기에 대한 세금을 내지 않아도 되는 그건 아주 큰 혜택이 있습니다. 그렇기 때문에 또 한 가지 예를 들면 제가 돕는 단체 중에서 국제적으로 변호 활동을 하는 노예도 구출하고 변호도 하고 인신매매 당한 아이들도 구출해서 또 법정에서 변호하는 그런 법률 단체가 있는데 이 단체의 기부 모금 운동을 제가 몇 년을 도와주고 있습니다. 그래서 뉴욕시티 안에서만 하는 그 모금 운동을 매년 저희가 하고 있는데 그거를 할 때 저희가 그 기부자들을 초청을 하는데 많지도 않아요. 200명, 250명 이렇게 초청해서 2시간 동안 프레젠테이션과 함께 식사를 나누고 150만 불 정도를 저희가 모금을 합니다. 그렇게 할 수 있는 이유가 그 200명 정도 오신 분들이 전부 다 재벌이나 이렇게 개인 재산이 많으신 분들이라서가 아니라 물론 그런 분들도 있지만 그냥 보통 소득이 있는 분들도 있는데 그 안에서 내가 이만큼 기부를 했을 때 많은 혜택을 받을 수 있고 그 혜택을 받는 그 이유가 좋은 일에 쓰기 위해서 그리고 또한 이 단체가 여러 해를 지나면서 지켜보는 가운데 정부에다가 리포팅하는 보고하는 그런 의무들을 다 하면서 투명성을 보여줬기 때문에 그런 레퓨테이션이 있고 그럼으로 인해서 이 200명 이렇게 작은 숫자지만 이분들이 믿고 그 2시간 안에 150만 불 이상을 그렇게 돈에서 같이 할 수 있는 그런 환경이 되는 것입니다. 그런 제도라는 것을 좀 이해해 주셨으면 좋겠고요. 제가 조금 더 이해를 돕기 위해서 왜냐하면 근본적인 그 비영리에 대한 정의나 그리고 비영리를 돕는 그런 제도 자체가 많이 각 나라마다 다르기 때문에 미국 같은 경우는 이제 이런 식으로 이해하시면 또 쉬울 것 같습니다. 예를 들면 제가 NPO를 자동차에 비교를 하겠습니다. 그러면 어떤 NPO는 뭐 노인들 전용 응급차가 될 수도 있겠고 장애인들 전용 버스가 될 수도 있습니다. 아니면 어린이들에게 음식을 배달하는 배달차가 될 수도 있고 다른 차들을 돕는 견인차가 될 수도 있습니다. 다른 NPO들을 돕는 NPO가 있을 수 있기 때문에 그런데 만약에 도로공사라는 그런 기본적인 인프라가 없다고 한다면 자동차는 많이 있지만 각종의 자동차는 많이 있지만 그 자동차들이 제대로 역할을 해내기가 굉장히 힘들 것입니다. 예를 들면 응급차는 병원에 시간 내에 신속하게 갈 수가 없을 것이고 그리고 배달차는 또 도로가 안 좋으니까 사고가 날 수도 있고 또 길을 잃어버릴 수도 있을 것입니다. 이런 상황에서 그 도로와 다리와 그리고 도시계획과 같은 그런 인프라를 만들어주는 것이 미국에서는 비영리 법 제도이며 또 비영리 관련 법이 되겠습니다. 그래서 이런 인프라가 생기고 나면 또 어떤 작용이 있냐면 파생 사업들이 또 생기게 됩니다. 그런 것들이 무엇이냐면 저희 우리 데어 회장님께서 오셔서 설명을 해주셨지만 그런 비영리 관련 그런 컨설팅 펌도 생기게 되고 저 같은 비영리 전문 변호사도 생기게 되고 고속도로 휴게소가 생기는 것처럼 그런 것들이 생길 수가 있고 발전을 할 수가 있는 것입니다. 그래서 그런 좀 큰 그림을 그런 빅픽처를 생각을 하시고 저의 부수 설명을 들으시면 조금 더 도움이 될 것 같습니다. 그래서 오늘 세션 프레젠테이션을 통해서는 비영리 법인의 유형, 비영리 법인 설립 인과 과정, 그리고 선량한 관리자로서의 이사회의 의무, 그리고 오랜 비영리 역사를 통해서 배운 비영리 운영 모범 사례, 법인 해체 과정, 면세 법인의 유형, 세금 면제 신청 과정에 대해서 이야기를 하면서 비영리 기관 중 특별히 자선단체가 가지고 있는 대중과의 관계, 단체 내의 이사와의 관계, 국세청과의 관계, 그리고 법무장관과의 관계를 통해서 서로에게 주는 이 큰 그림 안에 혜택과 규제에 대해서 설명해 보도록 하겠습니다. As a review, the large legal framework for nonprofit organization is the formation and exempt status. And the formation is important because it gives a legal status, existence to nonprofit organization, a right to own property, right to apply to different benefits. And the exemption status is also another benefit that's important to remember that comes with responsibilities and duties. So I presented yesterday the definition of nonprofit or NPO is groups that are formed not for profit or financial gain, but for the benefit of the public, a specific group of individuals, or a membership of the nonprofit. And it can be formed as a corporation or unincorporated association. To qualify for nonprofit organization, it has to have non-pecuniary primary purpose. And it's formed for the benefit of the public, specific group or individuals that we just discussed. And it must have 3 or more directors, for example, in New York State. There are other states that require something a little bit different. But you gotta have at least more than 1 director. And you need to have an address to receive service. Because of the technology of current days, it actually doesn't have to be a physical address. And you cannot have a shareholder because the organization is owned by the public. And you cannot have a private enrollment or benefit or excess compensation. And this was a question also from yesterday. Directors are not compensated in any NPO. That is absolutely prohibited. Directors are volunteer positions, and they have a lot of authority and duties at the same time. Usually they're the ones who form an NPO because they have something, a mission that they believe in for the benefit of the public. The compensation is for the staff, and I'm a firm believer that the staff of NPO should be well compensated, but not excessively. There are 4 types of NPOs under not-for-profit corporation law in New York State. And the type is important because the structure and the purpose of each type can almost dictate whether or not the organization will be able to qualify as a 501c3 organization with the IRS later on. So because of this government structure in the United States where each state has its own government and has a sovereignty, but also there's a federal government that oversees the entire United States, that there are 2 different processes for getting the tax exemption because you can get exemption from the state tax and as well as the federal tax. And because usually federal tax is a lot more than the state tax, and when you're qualified for federal tax exemption, it's much easier to be qualified for state tax exemption. We'll focus on federal exemption. Type A is organized for non-business purposes and activities by and for the members predominantly, and it includes political, professional, or trade associations, social clubs, fraternity, and civic or athletic associations. And they most likely will not get 501c3 status because the primary purpose is not for the general public benefit, but it's for political interest or professional groups like attorneys groups, CPAs groups, or social clubs or athletic associations like soccer club that you have. And type B is similar to what we saw yesterday, 501c3 public charity, or private foundation, because the purpose is for charitable, educational, religious, scientific, literary, or cultural purposes, or for the prevention of cruelty to children or animals. And they most likely will qualify for 501c3 tax-exempt organization. And type B has a choice to have a member or not to have a member within the organization. Type C is organized for any lawful business purpose to achieve a public or quasi-public objective. So these are the organizations that provide childcare, technical support, or if you run a store where you give the income for the purpose of nonprofit organizations, then you can qualify for type C organization. So depending on the operation of the organization, you can qualify for C3 or you may not. And type D is a form for any business or non-business purpose, and it's formed under another section of New York law. So the example will be the Housing Development Fund Corporation, which is formed under the private housing finance law of New York State. So, and this is actually typo. Type D has a choice to have or not to have members, but this is a kind of organization that has also, is under the jurisdiction of another law in New York State, and very specialized. The incorporation process in New York, your purpose clause is very, very important. And certificate of incorporation that you have to prepare to be able to be incorporated in New York State is a very simple form. It's at most 2 pages, but the purpose has to be really well crafted, because if the purpose is too broad, it might be ambiguous to the IRS, so you might not get the tax exemption status. But if it's too narrow, it's going to restrict your operation later on. So the 4 steps are, first one is reserving the name of the organization, and 2 is preparing, and 3, filing the certificate of incorporation, and the last step is to hold an organization meeting. So let's incorporate a nonprofit in New York. So Haejin and Cheolsu are childhood friends from California. They recently moved to New York for work, and they live in the same apartment building. One day, they met Mr. Smith in the elevator, who's an elderly person, and they learned from him that Mr. Smith is very lonely. He doesn't have any friends. He retired, and he's new to the city, so he doesn't have any family or friends in the town. So Haejin and Cheolsu wants to help him and create a space where he can meet other elderly in the city. So instead of just doing it on their own, on a personal level, they wanted to commit to this mission. So they wanted to incorporate an organization in New York State and start an NPO to create this venue for the elderly to come together and share recreational activity. They wanted to name this organization 효녀심청법인. And in order to do that, you have to find out whether the name is available, because the public cannot be confused with another organization if a same or the similar name is used. So you have to first of all find out whether the name is available, and you have to reserve the name if you want to, so that no one else can take that name. The second step is to prepare a certificate of incorporation. And what you need on the certificate is very simple. The name, address, and the type of the organization, the 4 types that we just looked at, and the name of 3 directors, and the purpose of the organization, and that's when you spend the most of the time thinking about. And then since Haejin and Cheolsu want 효녀심청법인 to provide a place of fellowship for the elderly, they do not need to obtain additional approval from another government agency. If they want to create an organization that provides, for example, medical service to the elderly, then they have to obtain an additional approval from the Superintendent of Insurance and Commissioner of Health within New York State. The initial board of directors include Haejin, who's a lawyer, Cheolsu, who's a fund manager, and Kwang-soo, a college student who's studying social welfare and elderly care at his college. All of them, what they need to do, what they need to be in order to become a board of directors for an NPO, is that they just have to be over 18 years old. And then you file the certificate of incorporation, and it costs $110. And you don't have to have any asset. And then you hold an organizational meeting where the directors are elected. So the directors that you state on the certificate of incorporation is the initial temporary directors. And then you hold this meeting to officially elect them or someone else or additional people as the board of directors. And then, very importantly, you adopt the bylaws. And bylaws is an extensive document that outlines all the rules and regulations within the organization. And this is a very important document that you have to refer back to whenever there's a decision has to be made within the organization. And then other businesses such as authorizing an opening of a bank account and filing the application for tax exemption status are decided at this meeting. Very easy. So you have this non-pecuniary purpose through directors, one address, $120, and boom, you have a new organization. And the bylaws are, as I said before, rules made within the organization that are used to control the actions of the members, directors, and officers. And when it says control the action, it basically means that there has to be certain rule that the governing body has to follow, the rules and procedures. And the reason why you need that is to protect the decision makers, not to control their actions per se, but make sure that there's rules and regulations and procedures that's set in place, so when there's a decision made by the decision makers, then they can rely upon this rule that they follow the rule, therefore their decision should be respected. The fiduciary duties of the board of directors is very important, and this is actually codified. We do have a common law, which is the case laws that talks about and imposes this kind of duties to the directors and officers, but it's also codified and mandated by the not-for-profit corporation law in New York State. And that is duty of care, duty of loyalty, and duty of obedience. And that is very similar to the Charity Commission also discussed the 6 duties of the trustee. So duty of care requires the directors and officers be attentive to the organization's finances and activities, and actively oversee the way in which assets are managed. So the core goal is to protect the organization's assets. And the rule is prudent and informed decision-making. And the million-dollar question that you have to ask yourself is, what would a prudent person in a similar situation and similar circumstances do? And business judgment rule applies and may protect directors from liability. And that's also very legal language in there. But basically, if you make a decision as a prudent and informed person, then your decision should be respected. So let's go back to our example, our organization that we just set up, 효녀심청법인. So 효녀심청법인 offers a facility for the elderly to meet. So the board of directors approves the organization's plan to purchase a building in New York City. This building is bought for the organization for the purpose of running a venue for the elderly. And the building has several rooms that can be used as an office. And because this organization is very young, it doesn't have all the programs to use up all the space in the building. So there are some empty office spaces in the building. Charsu, one of the directors, spent a lot of time and energy to start this organization. And of course, his efforts should be recognized and honored. And as a fund manager, as his profession, he wanted to use the empty space of the building because they were just available. He's not providing any financial service to the elderly that 효녀심청법인 is serving, but he wanted to use the empty office space to meet his own private clients. Since these are empty offices, Charsu didn't see any need to ask or any harm in using the space for his private benefit, although he was not paying any rent to the organization. And because of his use of the building, the organization had to pay a bigger electricity bill. In this situation, Charsu failed to fulfill the duty of care because he used the organization's asset for his private benefit. And at the same time, Haejin and Kwang-soo also board members, they also fail to comply with their duty of loyalty, because the reason why they didn't say anything about this is because they didn't know about it. They didn't read the financial report. They didn't read the staff report about the organization. They didn't attend a board meeting where the usage of the building was discussed. So in that situation, all of them fail to meet their duty of care. The second duty is duty of loyalty. I'm going to skip some slides because I think we're running out of time. Duty of loyalty requires that directors and officers pursue the interest and mission of the organization with undivided allegiance. So the core goal is to act in the best interest of the organization. And the rule is undivided loyalty in the best interest of the organization. And the million-dollar question that you have to ask is, did we follow the proper procedure? So let's assume the following situation. The board of directors of 효녀 심청법인 decides to hire a CEO to run the program of the organization. Kwang-soo, one of the board members, highly recommends his sister, Hyun-soo, to the board, but he does not introduce her as his sister, but only as a professor of social welfare and elder care at a college. And Kwang-soo has a conflict of interest in this situation because his information, his relationship with his sister is not disclosed to the board of directors. And Haejin and Chulsoo are too busy to consider other candidates, so they decided to accept Kwang-soo's recommendation without further inquiry into her qualification or interviewing her. Kwang-soo convinces the board that Hyun-soo should receive a salary that is 30% higher than the other organizations that's similar, the organization that's providing similar services, because Hyun-soo has a great reputation in academia, which is true. Again, Haejin and Chulsoo accepts Kwang-soo's recommendation without further inquiry. At the time of voting to hire the CEO, Kwang-soo participates and votes, and then the hiring and then setting of the salary of Hyun-soo is approved unanimously within the board of directors. In this situation, Kwang-soo, Haejin, and Chulsoo all fail to fulfill their duty of loyalty, because Kwang-soo failed to disclose his personal relationship, and he failed to recuse himself from voting. And also, Haejin and Chulsoo failed to consider other candidates. They failed to do the due diligence to hire the best person, best CEO for the organization. Duty of obedience requires that organization act within the corporation's purposes and that it fulfills its mission as set forth in the certificate of incorporation. So the core goal is to achieve the organization's mission, and the rule is follow the rule. The question to ask, and this is important, it is, does this legally, whatever you're doing, does this legally advance the mission of the organization? And the directors must exercise meaningful oversight to ensure that the organization complies with the law. So now, 효녀 심청법인 wants to add another director in order to diversify and grow the organization. So Junbam is a businessman with a prior board experience in another charity, and he has a great network of people that he knows, a great candidate for a board. Junbam is excited about the mission of 효녀 심청법인 and diligently participates in the board work. And he even volunteers in the program. And after observing the operation of the organization for about 3 months, he finds out that these elderly population that 효녀 심청법인 is serving do not have a medical insurance. So Junbam discusses with the board about a need for starting a medical center for the elderly. But it takes additional effort and money to have another facility for a medical center. And they also need to obtain government approval to have a medical center. So they decided to avoid all that process, and without the approval of the government, they decided to have a medical center. And in that situation, the board of directors have failed to comply with the duty of obedience. So this is actually an illustration from yesterday, but the director has to do his duty while exercising the authority that he has. I think we ran out of time, actually. So, I mean, these are, you can just read them yourself. These are very interesting examples of the enforcement that the Attorney General had against some pretty bad and defrauded NPOs and directors. And it ended up being the directors or the NPOs or both of them sometimes having to pay a lot of money in damage, millions of dollars sometimes. And also the Attorney General has the authority to basically ban the board member from serving in another organization as a board member. And then I have a few slides regarding the best practices of an NPO. And these are not the statutory rules, are not required per se, but these are highly recommended best practices for the NPO to achieve the transparency and the accountability that it seeks. And dissolution of a nonprofit organization actually is not as easy as incorporation or obtain a tax exemption status. You can start an NPO in the United States fairly easily in any states. However, dissolving an NPO is not as easy because it requires final accounting of all the reporting requirements of the NPO, as well as restriction on asset distribution. So when the NPO is dissolved, the asset has to be distributed to an organization that has a similar purpose. And I described it as a 12-step process. It doesn't have to be 12, but it's a very lengthy process that requires internal approval with the board of directors, as well as the members, if the organization has a member, and also external approval from not only Attorney General, but from the court. Okay, and the benefits of federal tax exempt status, we talked about that quite extensively yesterday. And there are a couple other kinds of 501c tax exempt classification. C3 is what you probably know fairly well, public charity and private foundation. But C4 is a social welfare organizations, and they have a different kind of purpose. And under C4, you can also have a lobbying organization. I know lobbying has a very different meaning in Korea, but in the States, lobbying is used to seek legislation that serves the organization's mission. So they are recognized as a nonprofit organization. And it can also receive the tax exemption status. However, individuals donating to a C4 organization do not get tax deduction. And C6 is a business league. So simply put, these are organizations, it's a professional organizations, athletic organizations. They come together to share their hobbies or interests. And they can also become a tax-exempt organization. And then these are the forms, 1023, 1024, very technical, but you have that information. And what IRS did last year is that they introduced a very streamlined 3-page tax-exempt application. So it used to be 26 pages and it used to take about 9 to 12 months. But now, as long as you are this kind of organization that has gross receipt of $50,000 or less, or $250,000 or less of an asset, then you can use this 3-page form and you can obtain tax exemption status in 3 months, which is very fast. So again, very streamlined process for tax exemption. Okay, so this is, if you look at this, the birth of an NPO at the time of incorporation, you enjoy this very streamlined process as well as opportunities to apply for tax exemption status. But then to grow and have an impact in the society, you have to abide by the duties and responsibilities that compels transparency and responsibility and accountability. And at the time of dissolution, you must undergo final accounting and approval process. And then the last slide that's in your, here. The last slide, it shows the relationship of these different parties here, and then the public in this chart is not necessarily the public that receives the benefit for the purpose of explaining this illegal relationships, but public as a donor. And the benefits and the duties that each relationship has, and these are very committed relationships, and these relationships demands certain duties and offers certain benefits. And I hope this kind of explains and help you understand the kind of the framework that the United States has for nonprofit organizations. Thank you.